Okay, well, we can go ahead and get started. Looks like we've got some folks rolling in. All right, so welcome. Thank you guys all for joining us today on this lovely Wednesday afternoon. This is going to be our introductory seminar for trusts and wills, kind of a what you need to know. We're here to just give some information out, hopefully educate some folks on what's a will, what's a trust, where do I start, how do I kind of wrap my head around everything that's going on with estate planning. So that's what we're here to do today, hoping that you take away some good nuggets of information, that you can go in more confidently into the estates conversation from this point. And of course, if you have follow-up questions, please let us know. Let us know feedback that you have about this seminar. Let us know if there's something else you want us to cover or go more in depth on. We're looking forward to hosting some more sessions like this, at least one every month. So we're open to all the ideas and feedback, and we really appreciate y'all joining us today. So we have three of us that are going to be hosting. I am Rebecca Melone. I'm the owner and founder of Melone Hatley P.C. We're a family and estate law firm, and we have offices in Virginia, North Carolina, and Florida. And so also hosting today, we have Paige Davis, who is our estate planning attorney based in Virginia. And we have Stephanie Hoffman, who is our estate attorney in North Carolina, and she's licensed in Florida as well. So we'll each be kind of speaking from our own jurisdictional backgrounds. If you have follow-up questions that are specific to your area, again, please let us know after the session. All right, so we can move on to the next slide. Okay, so today's agenda, we're going to tell you a little bit about our firm and kind of our background, where we're coming from. Why do I need a plan? Differences between will and a trust. This is a huge area that we get so many questions on. So this is going to be kind of the bulk of the information is what's the difference? Why do I want one over the other? That type of thing. We'll get into some Medicaid information and look back and how that all works, what a multi-generational trust can do for you, and then how divorce and how family law kind of plays in all on the estate planning side. Okay, so our mission as a law firm is that we help good people to protect their family, their finances, and their future. Our whole motive, our whole incentive is that we truly want to be our client's partner in the estate planning process. We're not here to just throw some paperwork at you and let you run out the door. We want you to be educated, well-informed, know what you're getting into, and be able to walk out confidently, knowing what you have in place and how it all kind of ties together. Like I said, we've got offices Virginia, North Carolina, and Florida. So those are going to be the jurisdictions we're primarily focusing on today. Okay, so like I mentioned, I'm the founder and CEO of Melone Hatley. We've been in business since 2014, so we're celebrating our 10-year anniversary this year. I'm super excited. We also have with us Paige Davis, and Paige has a background in both tax as well as estate planning. She's licensed in both New York and Virginia. And so she's helped clients sort of navigate that intersection between taxes and estates that can just be so very fun. And then we also have Stephanie, who's based in North Carolina, also licensed in Florida. And her background is primarily focused on litigation. So her practice is really going to focus on strategies to keep you out of court, right? We want to stay out of court if we possibly can. If we have to go to court, we have to go to court, of course. But for most people, it's going to make more sense if we can just avoid that altogether, keep things really simple, keep everybody on the same page, and get you moving forward. So behind the scenes, behind the three faces that you see on the call today, we've got a whole team of support behind us. So we have 50 employees across the firm right now. We have everybody gets to kind of wear their independent individual hats and do their job. So behind us, we also have a great team of paralegals, of support staff, everybody who's helping us out as well. So your attorneys at our firm really get to help you and focus on your case. They're not also trying to answer the phone and find new clients and do all the other stuff. So we are vastly growing and expanding. We're looking for some new markets to grow into over the next couple of years. But that's just a little background about us. All right. So first, why do I need a plan? Doesn't the government kind of already do this for me? So that's going to be my first topic. Most people think that the laws are going to be written so that it's obvious, right? If I pass away, everything's going to go to my spouse. Everything's going to go to my children. Everything's going to sort of automatically go where I want it to go anyway. So why do I need to do any planning? We can go into the next slide. So Estate planning in the United States is really designed to help you avoid some of these major expenses. So, across the whole country, we have over $2 billion spent on probate. What does that mean? That's after somebody passes away and you have to go to court and you have to file certain things. You have to do a report of the inventory and do accountings. You have to open a new bank account, all of this stuff, right? $2 billion that's just passing, not to the beneficiaries where you want it to go, but to the probate process. 75% of that ends up going to attorney's fees. Okay. So the bulk of the intestate estates, or estates that somebody doesn't have a will, or maybe they have a very basic will, this is what it ends up costing long term. Currently, we've got about 67% of Americans that have no will and no trust in place. And it takes about 1.5 years to go through the probate process. And that's assuming that everybody gets along. Nobody is fighting anything. Nobody's really contesting anything. That's just how long it takes to go from start to finish when you're taking an estate through probate. So we're here to help you cut down on those fees and expenses, give you the peace of mind, and get that money going where you want it to go, right? Into the hands of your beneficiaries. So this is the opposite of what we're trying to leave behind, right? Little caption here, one day, son, all this will be yours. This is not an ideal estate planning scenario. We're not trying to pass along a whole mess or a whole pile of stuff that our beneficiaries don't want to deal with, don't know how to deal with, and end up just getting rid of or taking much less than maybe it's actually worth because they just don't have the time, they don't have the resources, they don't have the energy to really dive into it. This is what we're trying to avoid. So, where does a will kind of fit into the picture? What can a will do for me? A will is a fabulous tool for some general planning. So, a will, number one, is going to name your executor. That's the person who's in charge of sort of managing your estate, collecting everything up, going to probate, filing those reports. You want somebody who's going to be pretty responsible with money. You want somebody who understands just tax filings and banking and reporting, things like that. Certain jurisdictions require you to have an in-state representative. So Virginia is one of those jurisdictions where it has to be someone who is a Virginia resident. Otherwise, it's really just a huge pain. Another thing your will is going to do is name a custodian or a guardian for any minor children. And the only real thing to note here is that it's not automatic. Okay, so if I say I want my sister to be my children's guardian, something happens to me and my husband, I want everything, taken over by my sister. I want her to take custody of my kids. The court doesn't automatically sort of stamp an approval on that. There's going to be some review and analysis by a judge to make sure this is an appropriate custodian. They're willing to take over guardianship. They have the capacity to do it, and then they can move forward. It's also a good tool for just sort of general distribution. If we've got a really, really small estate where we can sort of minimize the other filings that are required, we can do some general distributions. I want all of my money to go here. I want a certain percentage to, a charity or something like that. You can do that sort of thing with a will. Now, compared to a trust, a will is not going to give you the same level of control. So you won't be able to do things like give a gift to minor children and then say, but they can't have the money until they turn 25, and they can only have access to, a certain amount to pay for their school or their living expenses. You can't sort of micromanage the money in that way through a will. A will is also not going to avoid probate. A will has to go directly through probate. So that $2 billion that I mentioned, we're going through that whole process. We're taking that at least 1.5 years to go through everything. We're going to have all the fees and costs and everything else. You also, like I mentioned before, can't use an out-of-state executor, at least in Virginia. Jurisdiction by jurisdiction, it'll be different, but that can definitely be a major source of irritation as well. Okay. So what can a trust do? Well, a trust, number one, is going to avoid probate completely. Okay, so think about having like a beneficiary designation on a life insurance policy. Think about having a pay on death beneficiary on your checking account or a joint account holder where someone passes away and whoever is named on those documents just automatically is able to have title. They're automatically able to have control or ownership over that asset. A trust is going to act in very much the same way. So we're moving money from you into the trust. We're going to completely bypass probate. And then your trust is going to direct how and where and when you want it to go. So in naming who's going to be the person who controls this money, that is going to be your trustee. And this is the person who collects up everything. They distribute it out according to your directions. Again, you want somebody who's pretty responsible with money. They understand sort of basic accounting at least, but they can be out of state. And so if you have family members or friends or whoever who's across state lines, not a concern when you're naming them as a trustee. And then you have that added direction and control over your distributions. So with a trust, you can say things like, I want the trust to pay for my child's education, for their tuition, for their living expenses until they reach the age of 25, 26. Then maybe they get a certain percentage, right? Or maybe they get everything that's left in the bucket when they turn 30. You can have that level of control when you're using a trust. And you're not spending all that time, effort, and energy on going through probate before it gets there. Okay, so those are kind of the key differences between a will and a trust. So taking this case study, and this is based on a good chunk of our clients. So we're taking a husband and wife that have 2 kids, right, underage. They've got a house with about a fair market value of $600,000. Their retirement, their IRAs, their 401ks, their savings, their investment accounts all together is about $400,000. They've got a life insurance policy of about $200,000. Now, if this were going through either there's no will or if there's just a very simple will in place, if everything has to go through probate, the total cost of going through that probate process is going to add up to about $50,000 on an estate like this. So all of those fees and costs and everything else that's involved is based on that sort of top line dollar value. It's based on the gross value of the estate. And a lot of folks don't realize this. So even if there's a mortgage on that house for $599,000, we're still going to be basing the fees and costs on that fair market, that $600,000 mark, right? This makes a huge difference in what the fee structure looks like. Now compare that to the total cost of a trust with the same estate, not having to go through probate, not having to pay those fees and costs and all that. Total cost of administering it is going to be about half. So while a trust may be more expensive to set up on the front end, on the back end, it's going to be a significant savings for most people in a situation like this. All right, another little comic I found. Yeah, I inherited from my parents too. But by the time it was divided up, it ended up being 17 cents. That's not usually what we're going for. We're hoping to give a gift that's going to be substantial and significant and help our children along or help whoever our beneficiaries are in doing whatever it is that you want to see them do or they want to accomplish. So let's make sure that we're not chipping and chunking away with those fees and costs, and we're getting the bulk of the benefit where we want it to go. Okay, so now I'm going to turn it over to Paige, and she's going to tell us a little bit about Medicaid and kind of how that factors in.
Yes. Hello, everyone. Thank you guys all for being here. So I will get into Medicaid planning. A lot of people, when they hear Medicaid, kind of maybe think of Medicare. They are very much similar, but Medicaid is a very state and federally funded program. With Medicaid, the most important thing is that they do want to see that your assets are less than $2,000. Assets are only the countable assets. So I'm going to keep it real high level because we're talking about a lot of different things here. But when you think of Medicaid, you may not really think about qualifying now, but maybe down the road, or you or a loved one, your parents. So you want to make sure that you're thinking about not just now, but your future, right? Estate planning is all about thinking about the future and what does that look like for you, and even if you have elderly parents as well. So the first thing about Medicaid is you have to be, for the state of Virginia, you have to be a Virginia resident, okay? You also have to be age 65 or older. Now, a key thing again is even if you're younger than that, you also want to be thinking about the future. So, the way Medicaid works is that they look at your income, and your income is key. So, for the income, you have to have income that is less than the cost of a private nursing home. And we'll get into those costs later, but it is very much something that a lot of people, even, most people cannot afford. Let's just be honest. So, your income has to be less than the cost of the private nursing home, or you have to pay that out of pocket. So only income of the Medicaid applicant is counted. So that is a good thing if you are married. They don't count the income of your spouse. For the community spouse, they can keep all their income. So their income is not counted. However, when it comes to resources that they're counting, they are looking at both of you and your spouse's income. I'm sorry, resources. So even if your spouse has assets in their name, they are looking at your assets as well as theirs, even if your spouse has separate assets. So that's a key component. The other part of it is that there are some resources that are exempt. For example, your home, your primary residence is not going to be counted as a resource. So that is a good thing. However, if you do have rental properties or any other properties, that will not be exempt. So they're only going to go and count and not count your primary residence. They will also not count your vehicle. Whatever primary vehicle you use, they will not count that. However, if you have more than one vehicle, they will count that. So I won't get into everything, but there are ways to make sure that some of your resources don't count. But we're going to talk about more importantly how this relates to estate planning and what you can do now to plan for Medicaid. Again, we're talking about private, nursing homes or assisted living. All right, guys. So this is something that has gone up over the years. The astronomical cost of going into either a nursing home or again assisted living. So for Virginia, for this area, and of course it varies from different state to state. It varies based on what part of the state that you're in. So for this area in Virginia Beach, the Hampton Roads area, a nursing home just for a semi-private room is $114,000, $428. So it's over $100,000 for just a nursing home facility for 1 year. So imagine, you have your mom who's worked this hard to pay off her house, and that house is her only primary source of income. Not even income, but her primary asset, 'cause she doesn't really have a lot of income. She would literally, even her selling that house, say she makes, has 300,000 or however much, even with that one home, within 3 years, she could easily run out of money. So, and then who wants to have to sell their home? Why would you want your parents, to have to sell their home just to pay for them to have some type of care? Well, that is the reality that we're looking at now. Even for in-home health care aides, it's now $68,000 a year. And for assisted living facilities, it's $72,000 a year. So these numbers, guys, are continuously going up. It was a lot less last year. And so definitely with inflation, these numbers continue to rise. And so again, we have to think about, okay, what can I do now, right? Thinking about the future. What can we do now, whether it's myself or my elderly parents? And right, your parents' assets, if you're the beneficiaries of those assets, that is going to affect you, because that's going to eat up some of the things that your parents want to leave to you, because now you have to use all this money to pay for long-term care. So let's look at ways that we can actually tackle this and get ahead of it rather than on the back end. All right, so this is the most important thing. You really want to be able to spend down your assets. And what do I mean by spending down your assets? We are talking about a irrevocable living trust. We have revocable trust, we have irrevocable trust. Now, for the purposes of qualifying for Medicaid and having long-term care, we are talking about an income-only trust. So with that, essentially, the most important part of that is really looking at, there is a 5-year look back period. And so you can't decide, hey, I want to make sure I want to put my mom in a nursing home now. And what can we do to make sure that she qualifies and that some of her resources are not counted? Honestly, it would be a little bit too late. You want to do that well in advance. So we're talking about at least 5 years in advance. But you honestly want to have these conversations a lot sooner, because there's things that need to be done so that eventually when the time comes, you can qualify. So there is a 5-year look back rule. The planning has to be done well in advance. And we're talking about, again, qualifying for Medicaid. So with estate planning, again, you have revocable trusts, which are trusts that you can change and amend, and then you have irrevocable trusts. With the irrevocable trust, you want to make sure that the trust is actually funded. So it's not enough to just have a trust document. You want to have the trust actually funded with income producing assets, or it could also be, cash, investments. All those things could be funded into your trust. However, the only key difference between an irrevocable trust and a revocable trust is that you, as a grantor, are not the trustee. So you need to also have an independent trustee, which is something that you'll talk to an estate planning attorney, and they'll kind of explain that. But essentially, you are not going to be the trustee because you need to show that you do not have access to those assets. It's different than a revocable trust where you may be the grantor, meaning that you're the one who actually creates the trust, is your assets that you're putting into the trust, and you're also the one managing the trust assets as a trustee. With the irrevocable trust, which is income only trust, you are, as a grantor or the principal, only will have access to the income of that trust. And you want to make sure that income is less than the amount that would qualify you for Medicaid. So there's a lot of different ways to set this up. I don't want to get too much into the nitty gritty, but essentially this is something that you want to do thinking about long-term care for you or your parents. And it is also irrevocable. So you want to make sure that your beneficiaries are essentially the ones who are going to be receiving the assets, not yourself. So that's a key component. And again, you want to have an independent trustee. And you also want to make sure your tax ID number for that trust is separate from your own. So unlike a revocable trust where you may have your tax ID as the trust, as a tax ID for the trust, your actual social security number would not be used. You would have a separate tax ID number for that trust. All right, guys. So now we're going to talk about multi-generational trusts. Multi-generational trusts are also known as a different type of irrevocable trust. So we talked about irrevocable trusts as it relates to Medicaid. There are also other ways that you can leave and pass down wealth through to your decedents or your grandchildren, for example, and making sure that they are able to receive that inheritance and being able to have the assets skip a generation. So if I decide, I want to make sure that I leave something for my grandchildren, the best thing I can do is to have that asset not necessarily go to my kids, but to go to my grandchildren. Now, why would I want to do that? Why would I want to just leave, my assets to my grandchildren as opposed to my children? Well, a lot of it has to do with taxes. There is something called the generation skipping transfer tax. And for 2024, it was 13.61 million is the exemption for that tax. So a lot of estates don't obviously have to pay that. However, in 2026, there will be a sunset. And so that number will be cut in half. And a lot of people will actually have to pay estate taxes. So, you have to think about inflation. Right now, it seems really high. But however, in the next couple years, that number is going to significantly drop. And so you need to be thinking about now, how can I pass down wealth? How can I leave something for my grandchildren? And essentially make sure that they don't have to get that estate tax, but also making sure they get that step up in basis, making sure that I can actually leave them something without them inheriting a lot of taxes. So that's very important. You also want to think about your grandchildren's, college funds and things that you want to set aside for them so that they're able to also have money over time. You don't want everything, just to be squandered at once. And so if you are concerned about leaving a legacy and making sure that you're setting up not just one generation, but multiple generations, and making sure that those generations have access to all of the wealth that you built over time. And so there are definitely ways that we can do that here at Melone Hatley. We're happy to have a conversation with you about what that looks like for you and your assets in your estate.
Okay, awesome. So now we're going to turn it over to Stephanie, and she's going to talk about how divorce and sort of mixed families, blended families, and how litigation can factor into all of this as well. I think you're still on mute, Stephanie. There we go.
Well, it's good news is that marriages are still outstripping divorces and have been for the last 20 years. Marriage is still more popular, and as you can see, it's trending up, and divorces are going down. Luckily, most marriages still remain intact, 60%. Next slide, please. So, to prepare for the divorce, what do we have to do with estate plans? Well, when you make an estate plan with your spouse that you're getting divorced from, you have to update your wills because you probably have each other listed as executors and beneficiaries. If you have a revocable trust, like Paige was discussing, we have to back everything out because that may be a marital asset. it likely will be a marital asset in North Carolina, and I believe in Virginia as well. If you have children in common, then you have possibly college savings accounts. You have trusts in place that may be in effect, may be springing upon someone passing. You have to update healthcare powers of attorney, financial powers of attorney, and you have to deal with guardianship, because when you are divorced and you still share children, who is going to be the guardian if you are no longer there? And maybe your spouse isn't the best person to take care of your kids. We can take care of all of that through careful consideration. Next slide, please. So how does this impact your planning? One of the most common types of wills that people will draft with a will in the box or a website, just trying to get something in place so that they can avoid intestacy, is a reciprocal or an I love you will. It's very short. It says everything to my spouse, and that's it. This will not serve you if you're getting divorced. We would go in and revoke that will and write something more tailored to your situation. Same thing as if you've been married for a long time and you have an updated will and you're naming each other's families as beneficiaries of your will. That is something that we'd want to back out and not necessarily keep. You don't want to be supporting your wife's aunt in her retirement if, when you pass away, you'd want to update that to support the people that you care for after the divorce. Testamentary trust. We didn't really get into that. It is a trust that's made inside of a will that only goes into effect when the will is probated or administered. And it usually sets up a trust for children to take care of those, or for spouses. If you die and you have a testamentary trust set up for the benefit of your spouse, and you haven't completed the divorce process, or you have been divorced, some states will treat that as if your spouse has predeceased you. Some will not, depending on how the trust is written. So we need to actually review that document during the divorce process and make sure that we have something in place that meets your needs. Like I said at the bottom of that, everything has to be updated when the marriage ends. You don't want to be giving half of your assets or all of your assets to the person you just divorced from. Now, what if you actually took our advice and made a living trust, a revocable trust while you were married? We can back all of that out. We can end the trust. Joint family trusts, that would be, John and Jane Doe revocable living trust. We can split all the assets in there through an equitable distribution during the divorce, and we can set up new trusts that would still be tax advantaged for you. If you have a trust when you're coming into the marriage as something that you set up before you got married, that may not be a marital asset. It may actually be something that if you keep it separate and you don't have somebody and you don't dip into it for the sake of the marriage and you don't add marital assets to it, it can still be protected. Now, the same thing goes with inherited trusts. Great Aunt Susie dies and leaves you an inherited trust. There is, as Paige can say, there is some strict regulations from the federal government about when you have to withdraw that money, but it might not be a marital asset. It might be kept only for one spouse. And of course, children. Children are a blessing and they complicate our lives in wonderful ways. Estate planning and divorce, you have to take into consideration where the children are going, how the college costs will still be kept, if there's 529s, how those will be divided or kept separate for the children, who's going to be administering the financial lives of the children. Are you doing it together? Are you delegating one person to do so? And if you have a blended family and you brought children in from outside the marriage into your family, you have to involve the other parents as well. It's a complicated process. We can get you through this. But it's something to consider that will need to be taken care of in the process of your divorce. Next slide, please. Okay, so you've gotten married, and then you got divorced, and then you got married again. That's fantastic. What do we have to consider in that case? When you're married again, do you have existing wills from a prior marriage that we have to revoke? Do you have any family trusts that you're part of that have to be amended or restated? Who are your beneficiaries? Who's going to inherit in the case of your death? Do you even have children? How many separate people are the children from? We have to make family trees sometimes so that we can understand where you would like your money to go if you pass away. If you have any prior divorce obligations, that is something that we can consider through estate planning to make sure that the people that you are supporting through a prior divorce continue to have the support that you would like them to have, because your obligation ceases on death. But if you feel that you need to continue supporting them, we can take care of that. It's not in the normal divorce, it's not in the normal estate planning process, but we can take care of all of the people that you care about. And we can talk about prenuptial agreements before you jump into that second marriage. They're not considered part of an estate plan, and they're not always honored in a divorce, in an estate planning proceeding, but it does provide a clear guidance to your spouse and to the court for how you want your assets divided. We can incorporate, if you have an existing prenuptial agreement, we can incorporate that into your estate planning. Next slide. So there's a few other terms that I've thrown out there. What are marital assets? If you have life insurance for either spouse and there's a trust as a beneficiary, there's mixed guidance on whether or not you would like to add a trust as a beneficiary to your life insurance. There are definitely pros and cons on both sides. We would need to talk about what you would like to do with the proceeds of your life insurance upon your passing to determine which would be the best for you. If you have common investments, even real property, stock plans, other types of investments, those would need to be considered, those need to be divided upon the divorce, and we can either put those into an existing estate plan, update an estate plan, or some are best left with not going into a trust and going directly to a beneficiary. Now, vacation homes and rental properties. If you have a corporation, which is a little bit further down, or a partnership that owns real property or owns other assets, all of those can be incorporated also into a trust or multiple trusts with sub-trusts. It depends on how complicated your financial situation is, on what would be the best way to see you out of this divorce. Next slide. And then the last things to consider, guardianship. Now, guardianship doesn't just apply to children. It also applies to our elderly relatives. And when we start to age, who's going to be the guardian for us when we go to, as Paige was talking about, the expenses of nursing homes? If you are getting a divorce and you have guardianship over your spouse, how is that going to work? We can help walk you through that. There is a court process involved. You can't just be appointed guardian without going through the court. And if you're getting divorced from the person you're a guardian of, we want to see that other people are appointed next in line. Special needs, if you have children with special needs or adults that are sliding into dementia and may develop special needs, not only would you need to consider a guardian, but you would also need to protect assets so that if you were on a government program, you wouldn't get kicked off the government program. So this ties in with Medicaid planning. Divorcing is a difficult process, and if the spouse is a caregiver or subject to guardianship, or they are the guardian, all of these issues need to be considered in a complex estate plan. That's something that we can help you with at Melone Hatley.
Okay, awesome. Well, thank you guys so much for attending. Like I said, this is our first of these sessions, so we're going to be doing these on a more regular basis, and we'll kind of get into some subtopics of some of the stuff that we talked about today. But now we've got some free time, so if anybody's got any questions, We'd love to hear from you. If you want to post something to the chat or pop on and ask us, please do, and we'll see if we can answer your questions. Okay, apparently we made it all super clear, so that's awesome. That's always good news. But for any of you, if you want to talk in some more detail about your specific situation, your specific jurisdiction, please give us a call. We've got our phone number up on the screen. You can give us a contact at intake@melonehatley.com, and we'll do our best to help you out. We do a free initial phone call, so no commitment, no obligation. Just give us a call. We'll see if we can help you out and if we're going to be a good fit. And if not, then I guess we'll see you again next month for our next session. Thanks so much for joining us today.